So we're going to turn to the second portion of the program, in which we have several young historians who are going to be sharing brief accounts of their work with us today. I think that they're going to do their best to give us little cameos. First, we'll have Lynda Dodd, who's going to be speaking on Alice Paul's leadership and strategy in the campaign for the 19th Amendment. And she is a professor of legal studies and political science at the University of New York. She earned her JD from Yale and her PhD in politics from Princeton University, and previously taught at American University's Washington College of Law. She'll be followed up by Deborah Dinner. Did you want to use that? I'll do that. Should you want to jump? Yeah, okay. She'll be followed up by Debbie Dinner, who's going to be analyzing the neoliberal or conservative understanding that, in fact, have shaped American approaches to integrating work-family law. And she'll be looking at the question with the 70s, 80s focus, is that correct? Late 60s, early 70s. She's got a book-length project. And last but not the least, Mary Ziegler is going to be speaking about her forthcoming book, After Roe, The Lost History of the Abortion Debate, which is coming out from Harvard University Press in June. And so let's give them a chance to give us cameos. Thank you.
I think right there is okay. Thank you so much for inviting me to speak about my work on Alice Paul and the campaign for the 19th Amendment. My research in women's legal history focuses more on popular constitutionalism, constitutionalism in the streets. I'm writing a book now called Sisterhood of Struggle about the final phase of the campaign for the 19th Amendment. My goal is to provide a more analytical account of the campaign that's been offered thus far in the literature on the 19th Amendment. There have been a lot of colorful narratives about the campaign. A great biography of Alice Paul came out from Oxford University Press last year. But there hasn't really been an account that focuses on who actually did persuade President Woodrow Wilson to support the amendment. Was it the more conservative NASA, led by Carrie Catt, or was it the National Women's Party, led by Paul? So my research is designed to answer that kind of question. What I wanted to do today is take you through the various phases of the campaign. I'll show you some of my previous research on this. Here is Alice Paul. She's on the right when you're looking at the slide, holding up a banner with a quote from Susan B. Anthony. She often liked to invoke Anthony's memory in the campaign. In the book, I try to broaden the lens a little bit. I don't just focus on Alice Paul. I focus on her colleagues in the National Women's Party. And as I go through these slides, you'll see that, Alice Paul was really the strategist behind the scenes, but she had a group of dedicated radical suffragists helping her all across the country through the phases from 1913 to 1920. So she began by organizing a group in 1913 that would press Congress for the federal amendment. Those of you who know a little bit about suffrage history, you probably know that NASA was focused on state-level organizing for amendments at the state level. They were not worried at that point about a federal amendment. We're devoting no resources to it. So in 1913, she wanted to launch a campaign. She had just come from Britain a couple of years earlier. She'd worked with the Pankhursts, and she admired the militant methods that they had used. So her idea with her friend Lucy Burns was to plan a parade. And here's the program for the parade. She chose the date, the day before Wilson's inauguration, because her focus was really to give him a warning and to have a demonstration of power. She was not so concerned about persuading the broader public at this time. She wanted to focus on members of Congress and Wilson. The other thing I want to say about the parade, and something that really characterizes her campaign as a whole, is the use of gender in her campaigning. A lot of the parade memorabilia shows very beautiful women in clothes. She calls this the free woman of the future on the cover of the program. And she kind of played with gender roles a little bit. In the parade itself, she had professional women marching in groups. So she had physicians, she marched with the women who had advanced degrees, and professors. So she tried to play it both ways a little bit with gender, and she was really focused on what worked. She wasn't a proponent of an ethic of care kind of feminism or the social feminism that was prominent at that time. But she also used gender to her advantage. And one of the things you'll see in the parade, here's, by the way, Inez Milholland, the beauty on the gray horse, the free woman of the future, leading the parade. But one of the things she did like to do is really seize advantage and take advantage of any sympathy the public had when these women were put into harm's way. And in this parade, the New York Times said there were 500,000 people, the Washington Post said 100,000, but whatever the estimate was, there was a huge crowd in Pennsylvania Avenue, the first parade of this size. They crowded the marchers until there was just chaos. And so she milked this for all it was worth. You know, these poor women who had been injured. There were, the day after Wilson's inauguration, the Senate opened investigations. There was news coverage for weeks. So she really did try to take advantage of the helpless female who is being hurt in these events. And she did this repeatedly in her campaign. So after 1914, she began a new phase of her campaign, which focused on party accountability. She organized very conventional suffrage events like these are petitions to Congress, always concerned about spectacle and making these special events that would garner some publicity. Here are suffragists from all over the country on the steps of the Capitol singing, delivering petitions to Congress. After the Senate in the spring of 1914 did not pass with the requisite two-thirds majority, she decided to hold the Democrats accountable. So she organized in the West, and this is a feature of her campaign that I really do think is unique. She wanted to appeal to women voters. She was not really trying to get the sympathy of the men in Congress. She wanted the Democrats to see this was their self-interest because women would vote as a class in the West and harm the standing of the Democratic Party. And she also thought it was less humiliating to appeal to women voters. So you can see some of these campaign events, women in the public giving speeches. This is very unusual. Voting against the Democratic Party. This is both 1914 and 1916. Again, they tried to appeal to women. These women were demonstrating outside a speech that Wilson gave in the 1916 election. They were attacked, got a lot of publicity. Inez Milholland died during the 1916 campaign, and Alice Paul played this up. This became the motto of the National Women's Party, the image of her from the 1913 parade. So after 1916, even though her party accountability strategy didn't actually succeed in changing the outcomes of many of the races, she really did put the Democratic Party on notice. And I go through Woodrow Wilson's papers and show that he was worried about the long-term consequences of this kind of campaigning. When he began his second inauguration, she thought a new tactic would be necessary, so she started the White House pickets, and many of you probably are familiar with these. So I'll show you some slides from these. At first, it wasn't very controversial, but then after the war began, she tried to point out the hypocrisy of the Wilson administration and the Democrats for making speeches about democracy abroad when she felt like there was clearly a problem at home. This began, there she is. This began a period where they're getting arrested. This is a quote from Wilson here. "The time has come to conquer or submit." She's quoting his speeches. That's Alice Paul leaving the headquarters. So they went to jail, and this part of the story I think is more familiar to the general public, but they went to jail. Many of them served very long sentences. The publicity did force Wilson's hand. He had to change and publicly support the federal amendment. They were force-fed. I wanted to include this image because this is the cover of the Suffragist, the periodical for the National Women's Party. If you can see the language at the bottom, these poor women are put into the workhouse with Negroes and criminals. So not everything about the arguments they invoked were admirable, but they did make these arguments. Here they are finally leaving. And then the rest of in 1918 and 1919, they continued, even though they weren't going to prison for long periods of time, they continued campaigning incessantly for the Senate. They burned watchfires in front of the White House with all of his speeches. They sent all of the former imprisoned suffragists on a tour of the country until finally ratification. And here she is celebrating in Washington, D.C. This is Lady Justice hugging a suffragist, and it says "at last." Always this kind of imagery was very important for her. And then in closing, I just want to show you this slide because it's the beginning of her new campaign, which I don't feature in the book, but it's her campaign for the Equal Rights Amendment. So she had gone to law school after the ratification in 1920. She went to American University's Washington College of Law. And she decided to focus her efforts on an Equal Rights Amendment. She's at Susan B. Anthony's grave. She's launching this campaign, and she's invoking the memory of Susan B. Anthony to do this and brought publicity with her to do that. So I did want to say that, one of the reasons why I'm writing this book is the centennial of the 19th Amendment's ratification is approaching. And what I hope is that we'll take a moment to appreciate the resolve and the courage of this type of campaigning and what they accomplished then. Thank you so much.
Well, it's really an honor to be a part of this panel and so humbling. So I wanted to just thank the sections on legal history and on women in legal education. The book manuscript I'm working on is titled Contested Labor, Production and Reproduction in the Neoliberal Age. And it argues that in the late 20th century, the American public's conception of sex equality actually narrowed in important ways. So in the late 1960s and early 1970s, where the book starts, grassroots feminists and labor activists pursued visions of sex equality grounded in distributive justice. And then I show that in the 1970s and 80s, we did make incredible progress, unimaginable progress, in part due to the work, in significant part, of Ruth Bader Ginsburg. But grassroots feminists also lost a series of crucial battles. And most important, they had more success challenging sex role stereotypes under law, and they were met with more resistance when they endeavored to shift responsibility for social reproduction from the private family to the larger society. So as a result of this process, the American public came to understand sex equality as a principle grounded not in distributive justice, but in neoliberal conceptions of individual choice and a rational free market. So in my time today, I'd like to just focus actually on one single key episode told in chapter 1 of the book that I think illustrates some of its central contributions. So this episode concerns the labor feminist struggle to expand protective laws in the wake of the passage of Title VII of the Civil Rights Act of 1964. So as many of us know, since the passage of the 19th Amendment, the women's movement and the feminists within the labor movement divided into two camps: those who pursued maternalist protections for working women and those who pursued anti-discrimination laws that would offer women greater opportunity. But the passage of Title VII and the advent of sex equality as a legal principle offered a new opportunity, a new chance to realize a long-standing goal of the labor movement. And this goal was that of universal protective laws. So universal protective laws at the state level offered a chance to obviate or to get around a dichotomy. So it wasn't no longer either protection for the most vulnerable sectors of the workforce at the cost of sex segregation and unequal pay for women, or equal employment opportunity at the cost of the loss of protection for these most vulnerable workers. Instead, the hope to achieve universal protective laws was a hope to extend labor regulations at the state level to low-skilled and unorganized workers who didn't have the benefit of federal labor law or the benefit of the protection of a union contract. But unlike sex-based protective laws, universal protective laws couldn't be used by employers as a means to discriminate against women. So the chapter looks first at Michigan, where two activists named Caroline Davis and Myra Wolfgang, Caroline Davis of the United Auto Workers and Wolfgang of the Hotel and Restaurant Employees Union, joined together. And these women were actually formerly bitter enemies on the question of the ERA and sex-based protective laws, but now they joined together. And they fought to replace a progressive era law that limited women's work hours with a new law that limited the hours of male as well as female workers. So this state law, the voluntary overtime law, went beyond the protections of the Federal Fair Labor Standards Act, which required time and a half premium pay for overtime. It went beyond it by making actually overtime voluntary for workers so that employers couldn't retaliate against them if they resisted overtime. And it would cover all non-professional employees, not just those engaged in interstate commerce. So just a couple years later, in the early 70s in California, labor feminist activists fought a parallel battle. So they campaigned for legislation that would make a state administrative agency, the Industrial Welfare Commission, sex neutral, give it sex neutral jurisdiction, give it jurisdiction not only over the work hours and conditions of women workers, but also those of men as well. And in 1973, they overcame a veto by Governor Ronald Reagan and succeeded in passing legislation that would universalize the commission's jurisdiction. So what I think is important about these battles in Michigan and California is that it was a struggle to fuse a New Deal era commitment to labor protection with a newer civil rights era commitment to anti-discrimination. So it was really a contest over the legacy of the New Deal and what liberalism meant in the late 60s. Employers and politicians, however, committed to free market principles understood the liberal tradition in the US very differently. So sometimes they agreed with feminist principles. So for example, in Michigan, the big three auto company executives were willing to actually help implement Title VII's mandate by ending their compliance with sex-based protective laws. So indeed, the elimination of such laws offered employers greater control over the production process. The big three warned, however, that universal protective laws would come at the cost of business growth. So this argument really held sway over politicians as the nation transitioned from a period of relative affluence in the post-war era into a period of relative scarcity in the early 1970s. And it was these lobbying or opposition from the auto companies that led to the defeat of universal overtime bills in the Michigan legislature. So in California, meanwhile, business succeeded in capturing the Industrial Welfare Commission once it had sex-neutral jurisdiction, and business was able to capture it and thus at least temporarily eviscerate California's state protective labor standards. And so there was a battle back and forth throughout the 1970s. Employers, moreover, in California litigated under Title VII in their own self-interest to invalidate minimum wage laws for women workers, actually in industries of domestic labor where most of the workers were women to begin with. So this story, I argue, in the historical and legal literature is largely forgotten. And the decade following this forgotten campaign for universal labor protections witnessed, quote, the opening of the American workplace, to use historian Nancy McLean's provocative phrase. So we should celebrate the fact that white male strongholds in the labor market opened to women and minorities, as historians have recognized. But the workplace opened also in a second sense. So neoliberalism rolled back New Deal and Great Society commitments to welfare and to labor regulation. And the relationship between management and workers was opened in new and often unbalanced ways, favoring the power of employers over that of workers. So for some, liberalism came to mean freedom from discrimination, and for others, freedom from state labor regulation. So in conclusion, the book I'm working on, Contested Labor, makes three major contributions that we can see in this episode. So first, it broadens our understanding of feminist legal history. It broadens it to include not only the wonderful work done on the tremendously important litigation strategies of feminist lawyers, but broadens it to include grassroots activists within the labor movement and local women's liberation unions who focus not only on the courts, but also on institutions, their employers, legislatures, and state administrative agencies. So I contend that it's in the stories of Caroline Davis and Myra Wolfgang that we also must see some of the most robust visions for sex equality as a principle grounded in distributive justice. And second, contested labor also endeavors to shift our understanding of anti-feminist opposition to include not only social conservative opposition, but also market conservatives, people such as big three auto executives and state administrators in Reagan's California, as the most powerful source of opposition to feminist claims. And then finally, as a historical rather than as a theoretical matter, the book argues that in the late 20th century United States, the advent of gender liberalism was also intertwined with the rise of neoliberal policies that privatize responsibility for social reproduction. And this historical dynamic, I argue, is important to understanding the class inequalities that exist and deepened amongst women in the second half of the 20th century. So I hope that the book helps to recover visions of sex equality and directions for feminist legal advocacy that focus on issues of labor, class, and the welfare state.
Hi, everyone. Whoa, sorry. So when I think of engendering equality, or when I did in law school at any rate, I often thought of Roe v. Wade. And many of my mentors as legal historians had written books about the aftermath of Brown. So I looked in the library about books about the aftermath of Roe, and I didn't find one. So I, being a sort of foolish person, decided to try to write one myself. The journey took me to over 16 archives. I conducted oral histories with over 100 activists on either side of the struggle. Luckily, many of them were on the phone, some sort of strange people. And what I discovered was a world that little resembled the kind of clash of absolutes we now know, one in which compromises I would have thought impossible on other gender issues were reached, one involving an anti-abortion movement that was utterly exotic and unfamiliar to me. And so I wanted to understand how we did arrive at the present moment and what happened to the world of abortion politics that I myself had discovered. The answer, I think, that I have to give, which is unfortunately brief, is that Roe v. Wade was not to blame in as fundamental a sense as we now think. A variety of actors, social movement activists, judges, and politicians made decisions for both ideological and strategic reasons that helped to escalate the conflict. So I'll begin with the anti-abortion movement. We often think that Roe helped to launch a kind of popular revolt against judicial overreaching, one spearheaded by pro-lifers. But both before and after the decision, the anti-abortion movement and those I spoke to in it prioritized a fundamental right to life and often looked at unconventional legal sources in championing it. Those sources included international human rights law and often substantive due process decisions, including Griswold versus Connecticut, which they cited for the proposition that the unborn had unrecognized rights. Even after the court's decision, many in the movement faulted the court not for taking the abortion issue away from the people, but rather for failing to protect the unborn from democratic majorities. Indeed, when Congress proposed a constitutional amendment that would have chastised the court for its overreaching and returned the issue to the people, the leaders of every anti-abortion organization opposed it, seeing it as a betrayal of the right they championed. When movement members changed course, they did so for practical reasons. The emergence of the new right and religious right represented a powerful source of support for an isolated movement, and Ronald Reagan, who had seen himself as a champion of the anti-abortion movement as early as 1976, solidified his position in 1980. I think that the rise or turn to pragmatism in the movement tells a larger story about how it changed, and that, for me, complicated what I thought about backlash to Roe. This was the rise of so-called incrementalists, many of whom still dominate the movement today. The turn to incrementalism began in the 70s in what was then an educational organization, is now a public interest organization called Americans United for Life. Rather than arguing for a fundamental right to life or asking the court to overrule Roe directly, AUL attorneys argued that Roe, in fact, permitted many abortion regulations. And they had some success with this beginning in 1976, and more spectacularly in a series of abortion funding cases, ending with Harris versus McRae on the Hyde Amendment. When this began working, movement members as a whole rallied around the AUL and around incrementalism. Here was the path forward. They began championing only those laws thought likely to survive Supreme Court review. So were incrementalists who dominated the movement extremists, the kind of people we associate with backlash. Well, I think that depends on what we mean by extremists. On the one hand, AUL attorneys identified with the religious right and new right and made similar arguments, but did so, as their papers make clear, for unambiguously strategic reasons. On the other hand, AUL attorneys embraced what they themselves saw as compromises, putting off indefinitely the struggle for a perfect life amendment that so many had desired. I think this made me think that the movement we now know was not simply created passively in response to Roe v. Wade, but negotiated and renegotiated in the intense internal politics of the movement. The story of how Roe engendered or reshaped the pro-choice movement is equally complex. Often we believe that Roe at least partly poisoned the relationship between women of color and feminists, encouraging pro-choice activists to adopt a single-issue, choice and privacy-oriented agenda that didn't do justice to the needs of women who needed the assistance of the state as well as freedom from it. What I found in part was that the pre-Roe picture was a lot bleaker, at least in the pro-choice movement for feminists that I had thought. Often, feminists lost arguments about how to frame the cause to those who wanted, they argued, to achieve legal abortion for as many women as quickly as possible. Often, these self-proclaimed pragmatists focused on the desirable legal consequences of liberalization, including a reduction in deaths due to botched illegal abortions, to be sure, but also a reduction in spiraling birth rates, an argument that appealed to obvious supporters of legal abortion like George H.W. Bush, just kidding, who was interested in things like reducing welfare costs and appealing to what was then a very popular population control movement. After Roe, feminists were able to leverage a changing political environment that included scandals that rocked the population control movement and an increasingly militant politics of civil rights to argue that population control arguments were a hindrance, arguments about botched illegal abortions were an anachronism, and that women had a right to reproductive health services regardless of the policy consequences. Nor did an obviously single-issue abstract choice agenda emerge immediately after Roe. Indeed, after the decision, both in established organizations like NARAL and dissenting organizations like the Reproductive Rights National Network, feminists used the idea of choice, now so often criticized, to demand a radical expansion of the nation's reproductive health agenda, one that included not only freedom from state interference, but also access to free and publicly funded child care, health care, and protections from sterilization abuse. When they set this agenda aside, as Debbie argued, they did so partly because of a rapidly changing political landscape. Ronald Reagan won a landslide victory at a time when abortion opponents claimed majorities in both houses of Congress. Moreover, Reagan popularized, I think, in both political parties, a philosophy of neoliberalism that lauded the values of free markets and deregulation. At the time then, feminists had every reason to present themselves as the true champions of individualism and freedom, rather than those in favor of state-centered solutions. So I think faced with a choice between principle and pragmatism, many within the movement chose the more cautious path. Perhaps most surprisingly, I didn't find that Roe ruled out compromises, at least on other gender issues. As one activist put it to me, after Roe, I thought that ruling out compromise was like putting a gun in your mouth and pulling the trigger. For some in both the anti-abortion and abortion rights movement, compromise seemed more important than ever, at least on other gender issues. Abortion opponents pushed for things like bans on pregnancy discrimination and robust welfare legislation, especially for adolescent mothers. In major abortion rights organizations, including the ACLU, activists debated whether it would be possible to recognize fetal rights outside the abortion context in matters like human experimentation and fetal research that wouldn't, at least obviously or necessarily, conflict with women's interest in reproductive liberty. When these solutions came to seem out of reach, more than the Supreme Court was to blame. The new right and religious right offered both financial stability and political relevance to what had been an isolated anti-abortion movement with a leading organization in debt. The political landscape, and particularly the emergence of the Republican Party as the so-called party of life, made the equation even simpler for abortion opponents. And at a time when the Democratic Party was not obviously going to side with feminists, and when most anti-abortion voters were still voting Democrat, many feminists found that it was too risky to seem willing to compromise, and presented compromise as a political liability. So how did we get where we are today? I think the answer is messy. And here I'm reminded of one feminist. I asked this question, and she said, "Mary, we have no one but ourselves to blame." I think that's both a sad answer, but it's also a tremendously hopeful answer, because it means that the world of lost possibilities I experienced is one we could recreate in the future. Thanks.
So we're actually over time, but I thought at the very least I would ask Justice Ginsburg if she was interested in asking any questions or whether we should just wrap up, but I couldn't at least forego that opportunity. So you had been given no warning, and you're free to say no thanks, but absolutely.
I'm so old that I'm a member of the National Women's Party. And while you're in town, some of you might like to go to Constitution Avenue, just down the block from the court, to see the headquarters of the National Women's Party. And you'll see some memorabilia there of the famous Alice Paul. Rather than ask a question, I'd just like to tell a little bit of history, because this is a history panel. When Taft, whose preferred job in the world was to be a Supreme Court justice, was president, his wife told him, if you want to be a Supreme Court justice, you'll have to wait till after you become president. Anyway, he's finished with the presidency. He's Chief Justice of the Supreme Court, his dream job. But he says there's something wrong. We are being housed inside the Capitol. What is the third branch of government doing housed inside the first branch? So the Supreme Court should have a building of its own. They got the land, and one of the plots was the then headquarters of the National Women's Party. So the government offered some money to the Women's Party, and they said, no, this is a historic house. It was the temporary capital during the War of 1812 when the Capitol burned. And later, it was a prison for notorious Confederate spies. The government said, prove it. And a woman, Bernita Shelton Matthews, who was counsel to the National Women's Party, first she called at the eminent domain proceeding, a member of the Older Inhabitants Society. He said, yes, I remember it when it was a prison for Confederate spies. And then she introduced a photograph of a notorious Confederate spy, a woman, inside the building. The result was that the National Women's Party got what was then the highest condemnation award the United States had ever paid up till that time. And that was the result of the strategy of Bernita Shelton Matthews, who was appointed by President Truman, the first woman ever to be a federal district judge. And the last piece of information about Bernita Shelton Matthews, she chose only women as her law clerks. And why not, she said, because the others, all the rest of them, are choosing only men. So, and I had the good fortune to meet Bernita Shelton Matthews when she was well into her 90s. She was losing her eyesight and her hearing, but her brain was still working. And I think of where women are today and what it was like for the women in those days. I think we owe them a great debt for the work they did to bring us to the point we are now at.
Thank you, everyone. We'll give a hand to the panel.